The Trump administration just dropped a constitutional bombshell. It's actively considering suspending the writ of habeas corpus in deportation cases. This isn't some obscure legal footnote. It's a fundamental safeguard that prevents unlawful detention by giving people the right to challenge their imprisonment in court. So can Trump really do this? And what exactly does the Constitution say about suspending habeas corpus? In this quick look video, we're going to unpack the power of habeas corpus, dig into its constitutional roots, and explore when and if it can lawfully be suspended. We'll dive into history to see how past administrations handled this extraordinary move, reveal the tough legal hurdles required to justify it, and look at the intense reaction from civil liberties advocates. By the end, you'll have the tools to make your own informed judgment about whether suspending habeas today squares up with the Constitution. Habeas corpus, Latin for that you have the body, is often called the Great Writ because it's the core legal procedure that prevents the government from detaining someone indefinitely without cause. In practical terms, a writ of habeas corpus compels authorities to bring a detained person before a judge and justify the detention. It requires the executive branch to explain to a neutral court why an individual is being held. This mechanism has deep roots in Western legal tradition. It has been a pillar of law since King John of England and Magna Carta of 1215, which was designed to stop kings from throwing people in dungeon cells without legal oversight, something some kings were prone to do. The founders of the United States considered habeas corpus so essential to liberty and justice that they enshrined it in the original text of the Constitution, Article 1, Section 9. But why should we care about an ancient legal writ today? Because throughout history, people risked everything for it. In 17th century England, Christopher Love, a bold preacher imprisoned simply for challenging authority, the Book of Common Prayer, used habeas corpus to initially win his freedom. He was later executed for his political views, proving that standing up for basic rights has always come at a high price. The U.S. Constitution contains a specific provision known as the Suspension Clause that addresses habeas corpus. Article 1, Section 9, Clause 2 of the Constitution states, "The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it." In other words, the Constitution forbids suspending habeas corpus except in very narrow legal circumstances, only during a rebellion or an invasion, and even then only if public safety absolutely requires it. This language reflects the notion that habeas corpus should be inviolate in normal times, and only a dire emergency threatening the nation can justify its suspension. Notably, the Constitution doesn't explicitly say who has the authority to suspend habeas corpus, but historical practice and legal consensus indicate that only Congress can suspend the writ. Suspending habeas corpus is exceedingly rare in American history. It has only happened a handful of times, always in extreme crises. In over 2 centuries since the Constitution was ratified, historians point to only 4 instances that meet the criteria for a habeas suspension. Each occurred during a period of intense conflict, often literally on a battlefield, underscoring how extraordinary this measure is meant to be. Faced with an armed rebellion by the Confederate States, President Abraham Lincoln suspended habeas corpus in certain areas to allow the military to detain suspected Confederate sympathizers, spies, and saboteurs without immediate court review. In 1861, Chief Justice Roger Taney, sitting as a circuit judge in Ex parte Maryland, ruled that Lincoln's unilateral suspension was unconstitutional, asserting that only Congress can suspend habeas. Lincoln defied Taney's order at the time. Importantly, Congress later passed the Habeas Corpus Suspension Act of 1863, which explicitly authorized Lincoln to suspend the writ for the rest of the war. The congressional approval effectively validated the suspension. The Civil War represents the most famous habeas corpus suspension, used to address a massive rebellion threatening the nation's survival. Reconstruction and the Ku Klux Klan insurrection, another example. In the aftermath of Civil War, white supremacist groups like the KKK were violently resisting Reconstruction in the South. President Ulysses S. Grant, with Congress's authorization under the Ku Klux Klan Act of 1871, suspended habeas corpus in several counties in South Carolina, where the Klan was terrorizing black citizens and officials. This was done to allow federal troops to round up Klan members and quell what was effectively a domestic insurgency. It was a targeted suspension, limited in location and time. Once the immediate crises passed, normal legal process was restored. Now, during the U.S. colonial governance of the Philippines, a local armed insurrection against American rule led authorities to suspend habeas corpus in 2 provinces of the Philippines. That happened in 1905 when the Philippines was a U.S. territory and was aimed at suppressing a violent resistance, in essence, rebellion against U.S. authority in those provinces. Again, the suspension was geographically limited and tied to an active conflict zone. After the Japanese attack on Pearl Harbor in December of 1941, the territory of Hawaii, not yet a state at that time, was placed under martial law, and habeas corpus was effectively suspended. Fearing a possible invasion or sabotage after Pearl Harbor, military authorities took control in Hawaii, and civilian courts were closed for a period. The suspension lasted until 1944. Notably, on the U.S. mainland during World War II, the government did not formally suspend habeas corpus, even amid the internment of Japanese Americans, which proceeded under an executive order and was likely a grave violation of civil liberties, but not achieved by an outright suspension of the writ. The Hawaii case remains the only World War II related habeas suspension justified at the time by the invasion clause due to the imminent threat after the Pearl Harbor attack. Aside from these 4 episodes, the writ of habeas corpus has not been suspended at any other time in American history. Even when America faced major crises like the September 11, 2001 terrorist attacks, the U.S. government did not suspend habeas corpus. For instance, President George W. Bush's administration detained hundreds of terrorism suspects at Guantanamo Bay and elsewhere and tried to deny them court access, but it never invoked a formal suspension of habeas corpus. In fact, the U.S. Supreme Court ruled in 2008 that Guantanamo detainees, though non-citizens, held outside the mainland U.S. had a constitutional right to habeas corpus to challenge their indefinite detention. This ruling reaffirmed that unless Congress properly suspends the writ during a genuine rebellion or invasion, the courts must remain open to hear habeas petitions, even in wartime. All of this highlights how exceptional and how rare any suspension of habeas corpus is. It has consistently been reserved for moments of literal war or insurrection on U.S. territory, and even then employed only temporarily. Because suspending habeas corpus is such an extreme act, the legal standard for doing so is extraordinarily high. The Constitution's suspension clause requires that there must be a genuine emergency threatening the nation's stability or actual existence, either an internal uprising or rebellion, or an external attack, an invasion. And even in those situations, suspending legal rights is seen as a last resort to preserve public safety. The historical examples reflect these criteria. A civil war, an armed insurgency, an enemy attack. These all qualify as rebellion or invasion. By contrast, ordinary civil unrest, crime waves, or immigration surges have never met this threshold in U.S. history. Courts have made clear that the term invasion in this context has a very specific meaning. For example, in recent court battles over immigration enforcement, federal judges rejected the claim that a wave of migrants or even the presence of violent gangs constitutes an invasion under the law. As one judge explained, an invasion refers to a military intrusion or similarly grave hostile action, not an act of migration. Some supporters argue that the arrival of military-age men crossing the border illegally constitutes an invasion or rebellion, which the Constitution identifies as conditions under which habeas could theoretically be suspended. But historically and legally, this interpretation faces big hurdles. Courts have typically viewed invasion and rebellion narrowly, emphasizing armed hostility, organized violence, rather than immigration pressure. If the Trump administration can present clear, compelling evidence demonstrating a genuine invasion or a rebellion, evidence that meets stringent constitutional standards, it could potentially advance this argument in court. However, proving this would be extremely challenging and unprecedented. I'm not knee-deep in the evidence here. I don't know what the administration knows. The Trump administration has substantial hurdles to revoke habeas. But if it's sitting on compelling evidence, showing an invasion or rebellion is at hand, those unique facts could make or break this case. There's also the question of proper authority. Since the Constitution places the suspension clause in Article 1, the legislative article, most scholars and judges agree that only Congress can suspend habeas corpus, not the president acting alone. Chief Justice Taney's rebuke of Lincoln in 1861 rested on this point, and Congress itself reinforced it by eventually passing legislation to authorize Lincoln's actions. In every other instance of suspension, the executive acted with prior or subsequent congressional approval. Modern constitutional experts maintain a near universal consensus that a unilateral presidential suspension would be unconstitutional. This means that even if the Trump administration attempted to suspend habeas corpus by executive action, it would almost certainly be overturned. Now, for those concerned about rampant illegal or undocumented aliens in our country, we should really pause to remember that American system of justice favors roadblocks, deliberate tension, choke points. We don't follow a streamlined system of efficient courtroom proceedings. They're meant to be slow and studious to make sure everyone's rights are being protected. Because once the death sentence is carried out or a person's removed to El Salvador, those mistakes just can't be undone. It's normal to be emotionally worked up about a perceived invasion, about what sensible immigration looks like. But when we get charged up and emotional, we don't shrug our shoulders and ignore the Constitution. No, what defines us the most as America is how we honor that sacred document in even the most challenging of times. As it turns out, we can have both sensible immigration control and respect for the constitutional rule of law at the same time. We should insist on nothing less. Unsurprisingly, news that the administration is considering suspending habeas corpus in immigration cases has alarmed civil liberties and human rights groups. Advocates for due process and immigrant rights see such a move as a grave threat to constitutional freedoms. Observers have described the idea of suspending habeas as an extremely aggressive move that would dramatically escalate the assault on the rule of law by depriving people of any chance to challenge their detention or deportation. In the eyes of civil liberties organizations, removing judicial review from deportation proceedings would undermine a fundamental check on executive power. Some legal experts have reacted even more bluntly. One policy analyst noted, anyone advocating for the suspending of the writ of habeas corpus because they don't like due process is spitting on the legacy of those who fought and died for this country's Constitution. In more measured terms, groups like the American Civil Liberties Union warn that sidestepping the court sets a dangerous precedent. They argue that denying people their day in court, even people accused of immigrating illegally, violates the basic principle of fairness and could easily lead to executive overreach or mistakes going uncorrected. The Trump administration's plan to suspend habeas corpus and deportation proceedings presents a profound test of America's constitutional principles. On the one hand, the government argues it needs every tool available, even extraordinary ones, to address what it perceives as a national security crisis at the border. On the other hand, the right to due process and the independence of the judiciary are really cornerstones of the American legal system, which the suspension clause protects, except in the most extreme emergencies. History shows the United States has almost always managed to uphold its legal standards, even in times of peril. I think that reflects the greatness of our American system of justice. The current situation, while challenging, is probably not equivalent to those scenarios in the eyes of most legal scholars and judges. My one caveat: if the Trump administration is sitting on real evidence supporting the idea that a real invasion is at hand, then it can show the evidence in court and to the American people and see if it withstands constitutional scrutiny. The great writ of habeas corpus, that bulwark of liberty, stands as one of the most powerful symbols of freedom ever established by law. Its importance is etched deeply into history. People fought fiercely and even gave their lives for its preservation in England. knowing that without it, arbitrary imprisonment and unchecked power would reign. As we witness debates today, we are sharply reminded that safeguarding the nation must never come at the expense of dismantling the very liberties that define its greatness. Thanks for joining me this week. My goal is to give you the tools necessary to untangle today's constitutional controversies through my quick takes and deep dive videos. I hope you'll join me next week as we explore yet another constitutional controversy.